Welcome to Business Talk with Meghan McNulty, the podcast that takes you behind the scenes of business success and reveals the strategies, insights, and stories that drive these professionals to thrive in the ever-evolving world of business. Whether you're an established entrepreneur, a seasoned business owner, or simply fascinated by the world of commerce, this podcast is your front row seat to learn from the best. Each episode, Meghan will bring you engaging interviews with professionals from diverse industries who will share their triumphs, lessons learned, and the insights they've gained along the way. Hi, Larry. How are you?
I'm doing very well.
Thank you for being with us today. I know we've talked a lot about long-term care planning, and since you're an expert in this area, I know you do lots of estate planning, estate planning, law, and different types of trusts, but today specifically, I'm curious about the long-term care planning and how that works. So I'm happy for you to be here today.
That's good to be here with you.
So a lot of times people get confused about what are these long-term care planning trusts? What are they called? Is it a Medicaid trust? Is it a Medi-Cal trust? There's lots of confusion about it. So I have some questions I'd like to ask you. And the first one is, which most people are wondering, is what steps can they take to protect their assets from being depleted by medical expenses?
Well, I think this is right in line with the confusion you just mentioned, where people get confused between Medicaid and Medicare if they happen to be of the age where they're forced to be on Medicare. Medicare covers all medical expenses, your regular doctor visit, hospitalization, and some long-term care for a window of time. Medicaid is intended to cover long-term care expenses, the expenses that those who are considered to be indigent. And don't confuse that. I'm using a term as though you don't have any assets, but you can have assets and still qualify for Medicaid. It just depends on how we structure it.
Okay. So right now in the United States, we have the largest section of our population is actually aging and going into the next stages of their life where they will have to go on Medicare. And several families are wondering how they actually protect their assets long term. Are there legal tools or strategies that can shield their assets, let's say, from nursing home costs or long-term care expenses?
The answer is yes, but they're specific to each state. We happen to be in California, which has some of the most favorable rules, at least had. In January, there's going to be some changes. But even in January, I think we're still going to have very favorable rules that allow us to plan very effectively, no matter how large an estate is. Did that answer your question on that, Meghan?
It does. So there is ways to protect assets from the nursing home cost or the long-term care expenses that several individuals and couples might face here. How does Medicaid eligibility impact asset protection?
Well, if you're qualifying for Medicaid, if you're following what you and I do, we would be structuring a trust in such a way, we'd set up trust planning in such a way that the assets would first and foremost not disqualify someone for Medicaid, so they can receive the benefits. And if the trust is structured the way we normally do it, it creates creditor protection beyond the Medicaid qualification. So it has a dual purpose. Main purpose is qualifying your assets for Medicaid. Then the secondary benefit is it also creates some creditor protection, keeping other people from getting into it. And something that you and I have run into here recently is where you have a married couple, one of them has become incapacitated, they need long-term care, and now you're dealing with, particularly us men, where they're dealing with a remarriage or being manipulated. Irrevocable planning that is created for long-term care also creates strong remarriage protection. So you don't have to worry about a strange lady coming in, marrying the husband, which is, we men are the ones that tend to remarry, and having all the assets go to a strange family. So I know that's kind of off topic, but it's in line with what the effect of the Medicaid planning can be.
Right. And also helps preserve assets for what they need to be paid for, or they need to be used for, I should say. So
I guess that kind of leads me into, can I gift my assets to my family to avoid paying for medical bills and nursing home care? Is that possible?
Break it down. First, medical bills, you can't do anything to avoid those. That's where, for the people, the generation we're talking about, it's Medicare. So Medicare, with any supplement to cover those excess expenses, will pay for the medical expenses.
Got it. So Medicare will cover the bills. Okay.
It'll cover the hospitalization bills or doctor bills. And that's where you see advertising for a supplement to cover the part that is not covered.
Understood.
But in line with what you were discussing, can you transfer the assets? The answer is yes, but this is where a lot of confusion comes in, where people are told, you've heard it said, my wife has a boutique financial practice, and she'll tell people who are reading things on the internet that they're reading either financial pornography or legal pornography, meaning it's misleading them. It looks good and they think it's right, but it's not.
Right.
And that's where this place in particular is where a lot of misinformation comes in, where people think they know what they're doing and they don't. And what they're generally told is you can give your assets away to your family, your home, your bank accounts. And if you do that, you'll qualify for Medi-Cal here in California or Medicaid in other states. And then they'll hear some exceptions, and if you do that, then you have to wait a certain period. In California, almost everything you hear is not accurate. There's truth in it, but it's not accurate when they come to you and I to do the planning. So you may say you have too much. If you need to qualify for Medi-Cal, you'll have to wait a certain period of time. In the past in California, that was not the case. You and I could literally take someone who wouldn't qualify for Medi-Cal for 30 months, which used to be the maximum, and we could qualify them in 2 months, or we could qualify them in a month, even though they had more assets than they were technically allowed to have for Medi-Cal qualification. And again, that's where you and I run into people. They meet with us, and they say, oh, I transferred my home to my kids to qualify for Medi-Cal. And you and I turn to them and say, you didn't have to do that.
Right.
But anyway, and they take other action because they're misinformed. They've gone through that misinformation that they think is accurate, that if they had talked to you and I, they could have avoided all kinds of headaches. And we can address those, further down.
Okay.
Some of the issues you're wanting to talk about will address that.
That's important. Are there limits to assets they can protect while still qualifying for Medi-Cal or Medicaid in other states, I guess?
Well, in other states, you have, we'll stick with California right now.
Medi-Cal, yes.
Because in California, if you're single, right now, you can have $130,000 in cash assets. You can have qualified accounts, IRAs, 401ks that you can annuitize, or annuities for that matter, that technically are exempt. And then you can have your personal residence that is exempt. If you want to give the maximum protection, if you want protection, you don't need to do anything to qualify for Medi-Cal if you have $130,000 or less and you're single and you have a home. If you're married, you can have that same $130,000, add $65,000 on top of that, and then you can add another $65,000 per qualified beneficiary on top of that, and that's how much cash you can have, excluding IRAs and 401ks and annuities, and your home, and still qualify for Medi-Cal. What's confusing about that is if you can qualify, but if you don't take further action, you don't create a revocable trust, and you heard me correctly, a revocable trust, or an irrevocable Medi-Cal or Medicaid trust, when you die, if the state of California has a lien Medi-Cal expense that they've paid, the estate will have to reimburse the state of California for the monies that have been advanced toward your care.
After your death. Okay.
After your death. So even though you qualified for Medi-Cal, when you die, if there are liens that the state has because they've spent $200,000 toward your care, you qualified, but when you die, they're going to say, we have this $200,000 bill. How are you going to pay us back? And the kids are going to have to pay the state back against your estate, using your estate to pay it, unless they take other steps to create revocable planning if it's appropriate, and irrevocable planning if it's appropriate.
And that's where someone like you comes in to do that planning, or myself, and help them with that. Okay. I'm going to switch to another question that some people have a lot of confusion over is, what is the role of a living will or advanced healthcare directive in asset protection at the end of life?
Well, it's really not true asset protection. A living will is really just a document that says, hey, if I'm in a condition from which it's apparent I'm not going to make it, don't keep me on life-sustaining treatment. You know, if the cost benefit doesn't make sense and the chance of recovery is not good, use your best judgment, but withdraw. I'm saying withdraw the treatment if I'm in that condition. The advance directive gives the people you love and care about the authority to actually act on that living will, where you're saying to usually a spouse first and then possibly to the kids, hey guys, if I'm in a hospital, if I'm needing treatment, I'm giving you the authority to make medical decisions on my behalf, again, if I can't make it myself. And then I'm giving the medical providers, and this is critical, I'm giving the medical providers, anybody who has my medical information, permission to release that information to the people I love and care about, the people I've named in the advance directive. And on the same token, in that same document, that advance directive, we're giving them, the people you've named, the authority to receive the information. Without that being in there, the doctors, the medical providers are actually prohibited from disclosing your information to the people you want to receive it. And that's where the advance directive comes in. It also covers other areas where there might be conflict in your family, funeral arrangements, whether or not you're okay donating your organs, whether you're okay with allowing an autopsy, those type of decisions, funeral arrangements, so that if in the event of your death, there won't be conflict within your family because you've laid it out. Hey, I'm okay donating my organs. In the event of my death, I wish to be cremated or not. I'm okay allowing an autopsy, and then I'm okay end of life decisions. If I'm in this condition, guys, withdraw the treatment, which goes back to the living will, which now that portion of that is built into the advance directive, where you're saying, don't keep me on life support if I'm in this condition.
Very good. How can I plan for end of life expenses while ensuring I leave an inheritance for my loved ones? I think it's important to go over this again. So how do we go about planning for medical expenses while also leaving an inheritance? Let's just say, you know, I'm the husband, I'm the breadwinner in the family, have a lot of medical expenses, I die. How am I assuring that my wife is going to have money to live off of when I'm gone?
Well, first you look at the insurances that may be available. Life insurance is the most obvious, where you get it at an early enough age, you keep it until as long as you possibly can, so that could be a replacement of assets in the event of your death. The next insurance is dealing with health insurance, disability insurance, so that if you run into those unfortunate circumstances, the insurance replaces your income. It covers your medical expenses, so you don't have assets having to be depleted by your loved one. In this case, you mentioned a wife who has a husband who's lost capacity, and they have these great medical expenses. Well, now the wife is doing her due diligence, is going to end up having to cash out accounts, IRAs, 401ks, sell real estate, incur taxes that could have been avoided if you'd have planned it out in the beginning. And then the third aspect of that planning, Meghan, is to make sure you look at what your assets are. Try to anticipate what your income needs are, and then build it out. So these are my needs right now for my basic living, for the travel expenses, the vacations I want to take, we want to take as a family. And here's an extra cushion to cover those anticipated expenses. Life insurance, long-term medical insurance, make sure that you have the best you can possibly afford. Then I didn't mention long-term care insurance. If it can be purchased at an efficient price, see what you can get.
Okay.
Now,
So
long-term care insurance doesn't cover hospitalization. It covers the skilled nursing aspect, but I didn't want to leave that out.
and then again, we can also protect some of the assets through estate planning and certain trusts, such as revocable and irrevocable trusts.
Correct. And what that entails is structuring the trust in such a way that you qualify for the government benefits that would help replace or cover the expense.
Okay. What are some of the implications of joint ownership of assets with a spouse or a family member in asset protection planning?
Well, first, let's look at family members. And you and I see this quite a bit, where a parent trying to do this type of planning we're discussing transfers an ownership interest over to a child. Once they do that, they've created a potential mess. And what I mean by that is once you transfer ownership over to a child, now that child has a say in how you handle the asset. Usually it's a home or the personal residence.
Right.
So if that child gets sued, now that home is subject to the creditor coming after an asset that really isn't the child's asset. It's your asset, but it's now being used to satisfy a liability that wasn't even yours in the first place. It also creates potential tax issues, not immediate, but in the future, where you and I like to say there's a benefit to dying other than going to heaven. If you hang on to the asset for the appropriate amount of time until your death, then there's a benefit to that. And that what I mean by that is when someone dies, there's something called a full step up in basis. If you're married, there's a benefit here in California where an asset that you purchased, 40 years ago, you paid $100,000 for it, is now worth $2 million. The surviving spouse can now sell that asset for $2 million, zero tax. The capital gain is wiped out. Okay. If you transfer the ownership over to a child, you just lost that ability. And then you also lost the ability for what we call the second step up in basis. When the surviving spouse dies, or if you're single, you pass away, there's a step up in basis then, which means what you and I call a double step up. So okay. There's a step up on the first death. So in the example I gave, you paid $100,000, it's worth $2 million on the first death. And then on the second death, it's worth $3 million. Well, if it's handled properly, on the second death, the kids can sell it for $3 million, and that $1 million gain is wiped out.
So they won't have to pay taxes.
Yeah. Whereas if they transfer it to a child while they're living, that child is stuck with the $100,000 cost basis, which means there's now a huge tax.
Okay, wonderful. Okay, that's important things to know. Most people don't know. Okay, so my next question is, and I think this is important to just go over again, just because some of this is confusing and there's a lot of disinformation out there. How do I create a will or trust that minimizes the impact of medical bills and taxes on my estate?
Well, the medical bills goes back to the long-term care question.
And the insurance, okay.
And the insurance. So we need to look at what is your exposure? Do you need to structure your planning to avoid long-term care issues? And for most people, if you own a home and if you're single and you own a home and you have $130,000 or less in assets as of today, in 2024, the asset limit's going to go away. But if you want to make sure that the state of California doesn't come back at your death and take a piece of the asset, that's where setting up not a will, but a trust can be used to protect the asset from Medi-Cal reimbursement.
Got it. So your kids don't have to pay that bill and they can inherit the money pretty much.
Yeah. And then talking about taxes, what you're probably talking about, generally when people ask about taxes, they're not talking about income, they're talking about estate tax. Currently, the estate tax exemption is over $12 million, almost $13 million. Meaning if you die and you have an estate of less than that amount, the government's not going to take a piece of it. And when I talk about the government, we're talking about the federal government. The state of California currently does not have an estate tax. So you can die in the state of California and they won't take a piece of any of your assets. They may take it for income tax purposes,
right?
But they won't take it for estate tax purposes.
However, the federal government, like you just said, right now will allow you to give away $13 million before taxing you. But anything over 13 million, they're going to tax at what, 40%?
Yeah, at least.
And then that's changing.
Right now it's 40%.
Okay. And that's going to change. The law is changing. It's going down to 5 million in 2025.
Yeah. In at the end of 2024, it's going to drop back down to 5 million. And there seems to be some confusion that there'll be an inflation adjustment to that $5 million number. The way I'm reading the statute is they can take the position that there is no inflation index. So if your estate's over 5 million currently, then you need to plan on your estate being subject to federal estate tax when you die. Meaning you need to sit down with Meghan, with you, or with myself to discuss, here are the options to avoid that.
Okay, that's important to know. That's a big change. What role does a financial advisor or elder law or estate attorney, so an elder law attorney or an estate attorney, have in the asset protection planning? What role do they serve?
Well, they should be a quarterback for you. Our purpose on the legal side, and I guess it will also apply to the financial end, is to sit down with you and find out what's your why. What are you wanting to accomplish? I mean, as you know, you and I can do miracles with the planning. We can protect everything someone has, but if that's not their purpose, then we don't want to do that. We want to do what their purpose is. Our purpose is to find out, what are you wanting to accomplish? What is your purpose? And now, based on that, let's put some planning together to meet those needs.
Okay. And then who tracks the healthcare laws? So it seems like we're always changing healthcare laws. Who tracks healthcare laws? How does that affect our planning?
Well, you and I get updates on law changes. So we're able to see, here's something that's on the docket. The California legislature is looking to make this change. Well, obviously, we hear about what's going on the federal side. And then from that, we notify our clients and let them know this is what's happening. Be prepared. This is a change that may need to be made.
We know that for the Medi-Cal planning that's changing starting January 1st, the rules are going to be easier to deal with or harder, Larry?
Well, it's actually, the answer is I don't know.
Okay.
Right now, as we've discussed already, there were income or asset limits in the past. Starting in 2024, there are no asset limits to qualify for Medi-Cal, which means they're going to look at the income sources.
Okay.
As of yet, we don't know how they're going to be structuring it.
So there'll be a max income source. And then if you have too much income coming in, you won't qualify. Which
means we'll need to figure out a way to structure the income.
I see.
To still qualify.
But they're not going to take into consideration if you're living in $1 million house.
The way I'm reading it, the answer is no.
Okay, so that's interesting.
Be living down in Newport Beach.
Got it. So that's developing.
Which frankly, Meghan, is the way it's been in the past. You could actually have a home in Newport Beach and still qualify under the Medi-Cal program.
Okay, very interesting. And I'm sure lots of people will want to hear about that, because many people would like to be able to pass their homes, off to their children, and also be able to afford their medical bills and not have to sell their house to pay for medical bills. So I think I'm accurate in that statement, right, Larry?
Yeah, well, there are things that can be done, and that we're still in the unknown arena for 2024. We think we know at least some aspect of it, but I'm not confident how the income side is going to be treated.
Okay, good to know. What are some potential consequences of not planning for my loved ones?
Well, the consequences from that broad question is, in the event of your death, and death is easy. When someone dies, it's clean, because then all you have to do is get the death certificate. But without planning, now you have to go through potentially the probate process here in California, which means, to put it in perspective for people, if you have just $1 million in assets, and if you have a home here, you definitely have $1 million in assets. And we're looking not at the net value, but the gross value of the assets you have. You and I, as attorneys who would handle the probate, are going to take 4% of the first $100,000 in assets, 3% of the next $100,000 in assets, and then 2% of the next $800,000 in legal fees. And what we're talking about legal fees, it's the minimum legal fee. So it can be greater. And the larger the estate, the greater the fee. So if you're adding the math up with me, if you have $1 million in assets, you're looking at $25,000 in legal fees. Is that right?
Close to that.
$23,000 in legal fees if we have to probate it. And on top of that, another $3,000 plus in court costs.
Correct.
That's just the legal side. So with no planning, you're definitely subjecting the estate to that. And if you don't die and you become incapacitated with no planning, now we're in the unenviable position. Well, you and I don't complain about this because we get paid when people don't plan.
Right.
The problem is we end up having to go to court to give somebody who you probably already trust the permission to do what you would want them to do in the first place. That if you had put the planning together before you became incapacitated, we wouldn't be going to court. But if you don't, now we're in court. And then, of course, the tax issues, if you have a taxable estate and you've done no planning, now the federal government's going to take 40 cents on the dollar of that amount that is in excess of whatever the exemption amount is.
Oh, well, it's crazy. Hopefully, everyone understood the importance of planning after talking to you today.
Well, let me add one other thing, Megan, that you and I talk about quite a bit. If it's appropriate in your family, you may want to protect your children from scenario where they marry the wrong person. You and I call them the outlaws, where there may be a divorce scenario, and you want to make sure that the inheritance money you're giving to your child won't be subject to a divorce settlement. So it'll be protected. It'll be protected from a creditor. So that what you're giving to your child, the creditor can't come in and say, well, that's a nice pot of money, pay me. No, because you structured it for your child, that money's off limit to the creditor. And then another big aspect of that same planning is, what if your child survives you but doesn't survive their spouse? The scenario would be that the inheritance money now goes to their spouse, and their spouse remarries, and the inheritance money that you intended to go to your grandchildren is now going to a completely different family.
Right.
We call that remarriage protection. You can keep that from happening. So you can say, if in the event my child passes, or that my child's spouse passes and there's a remarriage, I'm not going to allow the monies that I'm giving to my child to go to a brand new family. It's going to be there for my child, possibly for my child's spouse, but ultimately it's going to go to the grandkids.
Wonderful.
And then the other aspect of that, Megan, is that also, if your child happens to be successful, it keeps the inheritance money that they're giving to their child from being added to their estate for federal estate tax purposes. Again, what that means is 40% of every dollar of your estate is now going to pay the Uncle Sam without the planning.
Understood. I mean, thank you for discussing this today. I think lots of people are confused about the roles of planning for healthcare expenses and estate taxes versus being able to plan for long-term care. And this was extremely helpful. And I'd like to do it again with you soon, break down some of these topics. It is a nuanced subject, and you really do need an expert in the area to go over it if you have questions. So thank you for being here, Larry. And is there anything else you want to add as we wrap up here?
No, I just think the podcasts you're putting together are critical for people to listen to see the gaps that may exist in their life and in their planning, and know that you are someone they can turn to and sit down face to face and address their circumstances one-on-one, and not have to worry about it becoming a public. You don't have to go to a seminar. By watching these podcasts, you're being educated enough to sit down and begin the process.
I agree. You can listen to it in the car, in your free time when you're getting ready for work or whatnot. So I thank you for your time and look forward to talking to you again here soon.
Well, you're very much welcome, and it's been my pleasure, and I look forward to our next podcast.
If you've enjoyed today's episode, please consider subscribing to the Business Talk podcast and leaving us a review on your favorite podcast platform. Your feedback helps us grow and improve. Thank you for joining us today. This has been another episode of Business Talk with Meghan McNulty.